I think we've already sort of touched on some of the other aspects like breach. The question that wasn't touched on, I think, is what would be the standard of care here? Would it be okay to use the reasonable person standard, or do we have to modify it like we did with doctors, for example? What do you think? So the standard of care analysis for the tort question, would it be the reasonable person standard, or would it be modified like we did with doctors, for example? Because we can't hold doctors to the standard of the ordinary reasonable person. It doesn't quite fit. So do we have to modify the standard of care?
No.
Why?
There's no profession in there, like no doctors, nothing.
Okay.
No specific profession.
There's no school for 4 years old?
Not like that.
I think there could be arguments on both sides.
Okay, how so?
So, on the one hand, yes, it's not a regulated profession, and there is no license for engaging in this type of service. But on the other hand, they position themselves as quasi-professionals, because they say they have the database, they have certain knowledge, that they have maybe certain
Expertise?
that allows them to match people.
Okay.
So, could be both.
So I guess, sort of to elaborate a bit on the point, it might be like a financial planner. Somebody holds himself out as a financial planner. There's technically no required degree for that. But do we hold them to, is there a different standard there than the ordinary reasonable person? There, I think what you're pointing out is there could be a debate about these sort of groups that are in the middle, that hold themselves out as having specialized expertise, but maybe in a lay sense, there's practically no training for that. I think, is that a fair characterization?
Especially for these online things like websites, so everybody says everything, so it's not 100% reliable like statements. So they might say we're expert or whatever, but where is the evidence that you're expert? For how many years you're doing these things? So especially this like technological things, I don't really know that much.
Okay. Causation we touched on with Spartak's point. I think here there wouldn't be, and we spent a bit of time on this, there wouldn't be a reason to modify the test for causation in this instance. It would likely be a but-for analysis. And I think one point that wasn't touched on it is, I think even if we say yes to all of those, there's a matter or consideration of remoteness. Does the loss or the harm flow from the wrongdoing? You know, Wagon Mound and Hughes versus Lord Advocate kind of set this broader perspective. We had the I forget the guy's name, but the one where the mice peed on him.
Yeah, is it mice pee or like something come from?
He stepped in it,
Yeah,
whereas the mice didn't pee directly on his cut,
yeah,
and so he couldn't have suffered.
yeah.
It was too remote, and I criticized that as sort of a narrow interpretation, but it's still within the spectrum of what the court can do. But reiterating the point, we sort of start with this broader criteria from Wagon Mound and Hughes versus Lord Advocate. But even at that, does that encapsulate things here? Is it stretching remoteness too far? That For Your Soul will be responsible in some way for Diana's well-being based upon these facts? Yeah.
I think yes, because let's say they married each other and lived for 10 years, had kids, and then
Like Two Little
something
Princes?
happened. And then, I mean, if we allow this type of claims and have dating sites responsible for matching services,
Yeah,
someone could really claim in 10 years that the marriage fell apart, you know?
yeah.
So it doesn't.
Maybe, although I think that those are additional facts that aren't present here.
But it's just about the scope of people who could claim, you know?
Yeah, no, I understand. I've been watching, do you watch the show on Netflix, Mindhunter? It's about, do you know one?
Yeah.
How do you describe it? The FBI Behavioral Analysis Unit, and just looking at serial killers.
Yeah, whether they are lying or not.
Yeah, so I think that's kind of your point. You know, people who purposely try to hide themselves for a long period of time, you know, that can be the case. But my point, my counter argument to that is just, if you get married and it's 10 years later, I would say that that's stretching
Yeah.
the remoteness a bit further than we would have, than would be reasonable. But if it was within a shorter period of time, maybe then there's a stronger argument. So what I've tried to elaborate here with what has been put forward is, I expect you to apply the cases. And I don't think it's unreasonable to say, well, how do the criteria fit? I try to be expansive in terms of, you know, rewarding a fit to some extent, but I think we can go, it can't go so far that it's beyond reasonability, let's say. So keep that in mind. How strong of an argument is it based upon the case law? And how, if you feel it's not quite as strong, but you're convinced this is the path to go, then reinforce it. Just like when you write an essay, you can see the weaknesses when you read it through, so address them. So I'm saying the same thing here. With your answers and with your understanding, equip yourself to reinforce your arguments.
In remoteness, are there any cases which we could say that they must?
Well, that's why I was referring to the Wagon Mountain Lord versus Hughes Advocate, and then Tremaine and Pike, I think was the name of the case with the rat pee. Sorry to refer to it that way. So you know, I'm just using those as examples. I think a key case is obviously Wagon Mound, because it sort of set the parameters. But we have some other cases there. And then we went into the financial basis of negating remoteness, of saying, well, it's too remote because it would cost too much, and we looked at those cases. Here, I don't know if we necessarily get into that, the cost aspect. It seems to be that first set of cases with Wagon Mound.
Would you have any concern about the intervening activity of the daily tweet, sort of between the causation issue? I mean, having...
Or even remoteness.
Yeah, even remoteness, yeah.
Yeah. How would you elaborate on that?
Would it have been foreseeable that the activity, the matching of the two would have then resulted in the ensuing activities, which ultimately resulted in the matter being published, the exposure being published?
So if
It's an intervening activity.
Yeah.
Would that obviate this remoteness issue?
it could, yeah, I think it could even hurt the causation.
Yeah.
Because you could say, well, everything was fine, and if I'm for your soul, for example, I'd say, well, we did not do anything.
Right.
You know, it was the Daily Tweet, I think it was
Yeah.
called, came in, took the photo, published it, and put it together with their own investigation into Charles. So that'd be another argument that can be viable.
Just one other point,
Yeah.
from a policy consideration, given the widespread nature of this dating service now, would Cardozo's concern about indeterminacy become an issue?
Well, I think somebody mentioned it before, maybe it was Balco? Did you mention indeterminacy?
I think we just touched on just for 2 seconds.
So, and I'm not sure how far indeterminacy would go here as an argument. The reason why I say that is,
Oh,
sir?
it says it there, that there's a novel, this novel opportunity.
Yeah, but indeterminacy will be an argument for public policy. And public policy is a question in both Ann's Kamloops and Ann's Cooper, just for simple reference purposes. So, just to provide an analogy, because we saw it work there, Imperial Tobacco. Why did it fail on the second stage, even though it was a novel duty of care? Indeterminacy, but we explained why. Because smokers weren't the only class of people that would have been affected. We have the people affected by secondhand smoke, their relatives, and so on. And that was what the Supreme Court said, well, that was indeterminate. With a dating website, do we have...
No, I'm thinking about the expansiveness of the possible litigants.
Yeah, but that's why I'm testing with you. So, is there indeterminacy when we look at a dating site? Because, using the analogy of Imperial Tobacco, it seems as though we just have the smokers. And the analogy I'm drawing is only people that sign up to use this site. It wouldn't be every site, right, or every dating site. Because there'd have to be a harm that came out of this. There'd be no necessarily widespread potential. The reason why it's widespread in Imperial Tobacco is because there was mounds of evidence about
I'm just
tobacco.
thinking of the floodgate issue here, because there's so many dating events that go bad, and people get all kinds of hurt and whatever. I mean, I understand the
Right.
Glouchlin issue about
Mhm.
the irregular nature is going to come in, but it's not a big point, but just as a matter of a line in the policy argument.
Yeah, as I'm saying, it can be made. What I'm pushing on is, what does that look like? And I'm pushing on, because you brought it up, but more for the group to see. It's not enough to say indeterminacy in here. You really need to elaborate, well, what do you mean by indeterminacy? Because at a surface level, I think we can say, well, that isn't indeterminate, it's just these people. So what do you mean by indeterminacy? I'm not asking you right now, I'm saying elaborate on the argument. Any other questions before we move to the final question? Yeah.
How do you look at defenses? Possible defenses?
No, we didn't really look at defenses, did we?
No, you didn't.
Yeah.
Asking.
Yeah, no, I wouldn't expect you to look at that. So if you've looked at it and you want to bring it up, you can. There's no expectation that you do so. If you apply correctly, you'd be rewarded, but it's not like everybody loses marks if they don't. Does that make sense?
Yeah.
Any other questions? So question 3. Question 3, I'm just for time reasons, I'm going to work through without giving you reading time, if you will. I'm hopeful that you've taken a look at it already, because I've mentioned we'd look at this exam. So, what area of law is affected here, or brought into question here?
Misrepresentation, negligence.
Yeah, so we definitely have negligent misrepresentation, so the tort. Is there a contract? misrepresentation.
Yes.
Possible,
Yeah, because Donald make a statement, a statement of fact, and it was a false statement and induce the other party to enter into the contract.
yeah. So if we recall how we started with the last one, using how Balkar did it, we sort of have this summary of what we think is happening that we'll need to itemize a bit more in order to plan out our response. So at first reading, it seems as though we have contract and tort, which we know you can put forward both. Why? What's the authority for that? Yeah. So the Supreme Court of Canada in 1993 in BG Checo versus BC Hydro said that plaintiffs can bring claims in both contract and tort and are not necessarily barred from bringing a tort claim just because this could be a breach of contract. So again, for clarity, I'm elaborating on this for the purpose of illustrating what you do on an exam. So in your plan, you might write BG Checo, but what does that mean? It means you elaborate on what impact that has here. And it comes at the early stage that you can theoretically have these two claims running concurrently, but you cannot recover for both. You cannot recover damages for both claims. So let's take a look at one of them. Is there one you want to start with, contract or tort? Okay, you're the first one to speak, so we'll do tort. So negligent misrepresentation, what did I tell you here in terms of the duty? A novel duty of care. So what case do we use?
So depends of
Right, but it's negligent misrepresentation. Imperial Tobacco. Remember, and forgive me for repeating, but it might be worthwhile. Established duty of care and negligent misrepresentation is Hercules Management. Novel is Imperial Tobacco. So we have the Imperial Tobacco case that gives us the criteria. So how do we apply the criteria from Imperial Tobacco? So there's overlap between Anne's Cooper and Imperial Tobacco, but we have certain particularized considerations with Imperial Tobacco that apply to the negligent misrepresentation scenario, such as the reasonableness of the reliance. We don't have that directly spoken to in the Anne's Cooper test. So that's why I'm saying when you're looking at the established or novel duty of care, these are the cases, looking at how the tests are constructed. So we have reasonable foreseeability of harm, proximity, the policy question, then second policy question, that's the Anne's Cooper test. The part of that part one deliberation is the reasonableness of the reliance, any sort of special relationship. And these are things that we see also in Hercules management. So if you're stuck, I guess one way to put it is you're applying the Ans-Cooper test with some of the factors from Hercules. That's what Imperial Tobacco is doing, if that's a more compact way of thinking about it. So remember, Imperial Tobacco is a really interesting case for the purpose, for what we're doing, because the Supreme Court finds a prima facie duty of care. I mean, if you remember, I talked about what that means. It means that 1A and 1B of Ans-Cooper, the court has found that there is a duty of care owed by the defendant to the plaintiff, but then we go to the more general policy considerations, and the court will ask, well, are there other factors here that should negate us recognizing a duty of care here? And the court in Imperial Tobacco said yes, indeterminacy of liability, because the government would essentially be liable to so many people, it becomes impossible to constrain what the duty of care would do here. So how would we apply that to the Donald and Jared scenario? Just the duty of care aspect.
Oh, there was a proximity, because obviously they have a contract.
Yep.
They were really, and for severity as well.
Right? What about the reasonableness of the reliance? Was it reasonable for Jared to rely on Donald?
I think it was because of him portraying himself as an expert.
Mm-hmm. Okay, so we might have competing arguments there. What Dayan said, I think, is just as viable as saying,
He's a seller who wants this, right?
yeah, that
Or the best
there might
price
be some
possible.
bias there. You know, somebody who's trying to sell something may not be the most reliable individual for an accurate assessment. Ebra, and then I'll come to you.
Yeah, but also Donald is in the best position to give an assessment to the hotel.
Mm-hmm.
Yeah, that's why it's reasonably he's relying on his opinion, because he's in the best position to give an advice about
Sure.
that. Yeah.
Okay. What about the proximity, public policy aspect? Who are the parties here? So remember, at this stage of the public policy with proximity, we're asking, should the court recognize, sorry, I'll come to you in a minute, I forgot. Should we recognize a duty of care between these two parties? Just hold that thought, and I forgot somebody's question.
I would say that because the seller is in a better position, possession of information that is not available to the buyer, so it's like the reliance is reasonable.
Yeah, so with those two, I would push you a bit further. I didn't with Ebra, just for time, but since you brought it up, what's your authority for that would be my question.
Yeah,
Yeah,
the case where the landlord who this guy, I cannot remember the name of the case, and the court said that he's the best person to.
Yeah. So there are a couple of cases there. We have Esso and Martin. That's where Martin was purchasing the franchise of Esso. We have Within O'Flanagan. If we look at it as a continuing obligation, that circumstances changed. And even if it might have been accurate at the time of making the statement, it changed later. Although I think it's doubtful that it was accurate to begin with, given the testimony from the facts of Eddie Fiss. So coming back to the proximity public policy consideration, should we recognize a duty of care between who? Who are these people? Not their names, but what kind of relationship would this be? Sorry? Yeah, purchaser and seller of a commercial property. So that raises an interesting question. If we're looking at a novel duty of care, should there be a duty of care owed by a commercial developer, property owner, and a potential purchaser?
That will bring in the good faith negotiating argument as well.
Not good faith negotiation though, right? Because
It's
there's
not.
no duty of care.
It's not.
Sorry, no obligation.
Right.
It does sort of remind us of that. So if that's how your thought process goes, you sort of write that down and park it, because that can come up with your contract analysis, right? Because I gave you a case where they said there's no duty of care in a negligent misrepresentation scenario. But it's a good thought. Where does that take us in terms of the public policy and proximity?
Good faith.
Okay. Understanding that I'm talking to mainly civil law jurisdiction people where good faith is more meaningful than it is in Canada. Yeah.
Bring me the good faith. The good faith and these pre-contractual situations that good faith you can, if you make disclosure, then you have to prove. But if you can choose to not to disclose, there's nuance between good faith.
Sure, and if you recall though, why I would say we don't need to go into necessarily good faith here is just, it isn't, in the tort aspect, it's not an argument that's gotten us anywhere. I'm not saying it's not a possible argument, but if we're thinking about, we have other viable points here. So we can say on the pros and cons, a property developer and a purchaser, there should be a duty of care here because we want, what?
Market interpreting.
Sorry?
Market interpreting.
Market?
Facilitate the market to operate like
Okay, yeah. The market operates in this way that they have to be able to rely on the other side saying things that are accurate. Maybe that's part of it.
Kawet Amtor, Kawet Amtor, the buyer of the area.
Yeah, that would go against it.
Yeah.
Saying, well, Jared should have done his due diligence. He should have hired Eddie Fiss before he purchased the property.
But,
So that may go to the reasonableness, actually, of the reliance by Jared.
but in here, it's not possible for the buyer to identify these defects before
Well,
getting into the property. Last time,
it's a common, and those of you fluent in commercial properties can speak to this maybe, but it's common when you're buying a property to have an inspection before you finalize. So I think here, maybe that can be a hurdle for Jared.
but I think it's not a policy reason not to accept duty of care of the seller.
No, it's almost worse, because it strikes at one of the criteria we need to meet, the reasonableness of the reliance. So it may seem we're kind of jumping around a bit. What I want to point out is, I think this is generally how things will go in an exam for you. As you're working through, you'll have these different thoughts about different things, write them down. But keep in mind where they fit. So we've just now sort of come on the idea, maybe there's another argument for reasonableness of reliance. We can return to that and elaborate on it.
I have a question. Why are you bringing the fraudulent misrepresentation here?
Because you'd have to prove, now you can. We started off, I forget who said negligent misrepresentation, but we start off with negligent. You can put forward fraudulent misrepresentation. hesitation I put forward, if you recall when we talked about it, was you have to prove intent. And we may read these facts and say, well, clearly Donald intended to mislead. It's harder to prove.
Yeah, but
So-
you can say that at the beginning.
Yeah.
Even though it can work,
So
but
in your
it's difficult
elaboration, whoever you're advising, you can say, well, I would suggest a negligent misrepresentation claim in tort, not fraudulent misrepresentation, because the criteria to meet are more flexible, whereas in fraudulent misrepresentation, you have to prove intent. And that sort of reminds me of, I saw your hand, I'll come to you in a minute, what Balkar said earlier, should we go through and say why things don't fit? And I said, you don't need to do that there. Here it kind of flows naturally, I think. We can say, well, here we're going to go for negligent, not fraudulent, because of the criteria. And if we're advising Donald, we can say, well, likely you are more open to a negligent misrep claim than fraudulent, because, you know, it's easier to prove. It's easier to meet the criteria. Balkar.
I'm gonna say, just to add on to something, so when we're talking specifically about reliance, so we could just talk about how, like, he is an entrepreneur, so it was negligent because he's been in this business. So
Yeah.
he has previous experience of buying and selling craft. And also you can talk about how, like, you know, it wasn't like in a social atmosphere, like a party or anything. It was just pretty much him and the
Yeah,
just talking
it was
directly.
definitely a business setting.
And then the case facts also mentioned too, like how he purposely, like, well, I guess purposely he did put in old furniture as well too, to probably just save on the cost of just in general, and probably trying to flip it for a profit.
Yeah,
So he does have a direct financial interest in the property itself. Right?
yeah, good. So, just so that we have a bit of time to consider the contract, not because we're done with the tort, but you know from the duty of care you go to the breach, causation, remoteness. But let's think about the contract claim, because we identified that there could be a contract claim as well here. What would that be? If I told you there were two, just to sort of move things along, what would they be? Or at least two, I should have said.
So it would be a breach of condition or warranty, depending on how you put this.
Yeah, there would be a breach of contract. We could put it more abstractly. And the sub-question being, is this a breach of warranty or condition? I think just to shorten things, to me at least, there's a strong argument that this is a breach of condition here, just because it seems to really go to an important aspect, the quality of the hotel. What would be the other contract argument? Or another?
Quality of the problem, light, the subject matter of the contract, the marketable quality.
Well, that's more of a sale of goods thing, and I don't think Sale of Goods Act applies to property. Like real estate, I mean, it clearly applies to property, but real estate, I meant. Well, if we're arguing tort misrepresentation, why can't we argue contract misrepresentation? Was there a false statement of fact, unambiguous statement of fact, made to induce the other side to enter into the contract? Maybe that's something to explore. So, but then, if we sort of play it out, at this point you're wondering, well, what do I do? Because I have this one tort claim, but I have two contract claims. If we had that situation, what are your thoughts? You have a misrepresentation claim in contract, but you also have a breach of contract claim.
Well, I think that maybe the issue is moot because of the damages. You cannot recover double. The damages,
right? But
they would always be the same.
that leads into the consideration. So what is it?
But in this case, there is no exclusion of liability clause in the contract,
Right.
and maybe it would be easier to prove the contractual breach.
The breach of condition.
Yeah.
Okay. I think here, we didn't. I didn't want you to deal with remedies or damages, but if you remember, we did deal with the outcome of misrepresentation versus breach of condition, which is damages. Misrepresentation allows for rescission. So the thing would be, what does Jared want? Does he want to keep the hotel and get damages to repair things, or does he want to rescind the contract? And that also factors into how we look at the two claims, the tort and contract, more generally. Exam questions are often written with different tiers in mind. Everybody will get, let's say, 60% of it. Some more will get another 30%, and then a few fewer will get the remaining 10. I would classify this last point as that remaining 10 point. I'm not, to be clear, I'm not saying anything about intelligence or anything, just it's more about sometimes you see it, sometimes you don't. Who knows? Maybe you're having a bad day. But there are these different tiers to exam questions. So generally speaking, going back to where I started tonight, when we look at the idea of a complete answer, this is what I'm looking at. But there's always so much there. I always like the metaphor of the Sherlock Holmes stories. I really like those. I don't know if you're as familiar with them, but the idea of Sherlock Holmes is this guy that can wring dry any set of facts, can just take everything apart and sees it all. I'm not asking you to be Sherlock Holmes, to be clear, because he's fictional. But the idea is that you have a set of facts, and it's almost like a challenge. What can you do with this? That's the way I look at things. And when I say what can you do, what's viable? There are a lot of theoretical things. I've tried to not be theoretical with you and to be a bit more practically focused. So within those parameters, what can you do with these facts? That's what I'm looking at here with the exam. So there's always, as I said at the start, there's always scope for everyone to do well, but there is scope for people to do just a bit better than others. So there's a lot there. So I hope that, one, clarifies expectations, what we'd be looking at, but two, also gives you an idea as to what I've been trying to do with you with the course, and really get into a lot of a more immersive engagement with the material, with these two topics that I think are immensely interesting and likely, unless you're in public law, likely of very practical importance for your practice, because everything in corporate commercial is sort of an extension of largely contract, but there's a lot of tort there with the negligent misrepresentation dimension. Yeah.
So, just to clarify, for the equation with contract and without overlap, you will have to mention which the best option, right?
You can, you can say, so let me back up. If we have a situation like BG Checo, where after everything you can successfully do both, which is sort of a rarity in itself, then you have that luxury of choice. Mm-hmm. And that's where I started with, when I explained the overlap, saying usually people will want the tort damages because that will allow for more, whereas a well-constructed contract usually has a cap. If there's no mentioning in the facts of a cap, you can say, well, presuming there's no cap in the contract, or is presuming there is a cap in the contract, go for the tort, or you may just weigh how strongly the two competing arguments might be. Do I have more evidence for one or better chance for one? So a question was asked before, do we need to know all the cases? I think because it's an open book exam, you should at least be able to look at all the cases. I think that's just reasonable. Like, I'll tell you how I did JD exams. I brought my notes in, but I had a table of contents, and I just used the table of contents as a checklist. I actually didn't read through my notes in the exam. They were just sort of there in case I forgot something. And maybe that won't be how you prepare, but what I'm trying to say is, don't look at your notes as the thing that will help you do well on the exam. Everything should be in your head. The notes are there to guide. If I forget, or if I'm a bit nervous and I want to make sure I'm not misremembering, then you go to the notes. Yeah.
I guess a clarification for the exam purpose. So those cases you're supposed to be familiar with all those prepared summaries. It's not beyond that in the textbook because there are four texts mentioned. So
Yeah, but remember why I mentioned the different texts, right? So at the beginning, I said to you, we have these two main textbooks. Who the hell are they? Who do we do for contract? Oh, Ben Ishay. Thank you. Ben Ishay, and then the Solomon text for tort. I gave you references to others in case those books didn't do it for you, and you needed something phrased differently. So there's no expectation that you know the difference amongst the textbooks. As I said, the only material that I can expect you to know is what we've covered in the notes. That is sort of the only floor, and as I said, the reason why I do that is everybody's at least on the same level, and as equal as it can be, it allows for people to do the best they can on a relatively equal footing.
helps a lot because we can just focus on those cases in the notes.
Yeah.
For the example.
Yeah, and also those are the ones that we took up. Yeah, we talked about those topics. So my expectation would be there's probably a bit more comfort with the cases that we've covered in the classes. But certainly, there are tiers in the cases. If we look at BG Checo, clearly is a key case for the contract tort overlap. Rankin's Garage, we spent a lot of time on. Exclusion clauses, we spent a while on. These are sort of topics that I got the impression people maybe needed a bit more time to think through. So, and that's why I have the exam further down the road for you, to give you this time to put things together. As I said, I like that idea from the UK where you finish your exams and then you have like a 5-week break, allowing you to put things together, whereas in Canada, we like sadomasochism, so we finish on a Friday and we have the exam on a Sunday. I don't think that gives enough time, so the exam is a bit further along for that. So you can reach me by email. My email is available on the site, the Osgood email. Other questions? And I should say, because we're getting down to 9, and we went overtime last time, if you have to go, I don't want to keep you. But if you have some questions, I'm happy to stay to answer some more questions. Yeah.
For the period leading to the examination.
Sorry?
I mean, just as if for the period leading to the examination, we still need some questions about the materials, but just send me an email and
Yeah, that's what I just said. But as a, you know, I would push the idea of the week before the exam, and even the week before the tort essay. Like, I don't do it because I don't want to answer questions. I really am concerned. Like, I've seen this happen, not with myself, but with other students. It's just so demoralizing to be told like a day before, you really, you know, do better on the resit exam, which is just horrible. So that's why I'm doing it. It also, I hope, sort of pushes you to be prepared in advance so that you have further time to sort of consolidate your understanding of things. Maybe practice with past exams, as I said, under time circumstances. Which actually, I'm suggesting something to you that I always did myself. I always wrote a few different exams in time circumstances as preparation, because the time management and the substantive stuff can be a bit different, but also really tests how well you know things.
Regarding paper, how do you
Which
see
paper,
that-
or both?
No, the paper, not the public.
No, which paper, or both?
Both.
Okay.
So, how do you see the not so legal online resources as a reference?
Poorly?
For example, news.
Poorly?
Something
that I do not understand is why people cite law firms' commentary. And I'll put it to you this way. If you're articling at a firm, let's say you're articling at Davies, and you cite something from McCarthy's, how soon do you think you'll be before they fire you? So I think you really have to look at authoritative sources. You know, if you're citing a newspaper article for something new that has happened, you know, like Uber has said recently, I don't know if this is the case, I'm not telling you anything factual. Uber has recently said they're going to challenge the Ontario Court of Appeal decision based on these points. Sure. But don't cite Davies' opinion of Heller, because I'm kind of hoping you have your own opinion. That's the point of the assignment. Okay?
For the tort assignment, do you have any points that we raise in the paper? Any guidance?
Can you tell us what to,
You talked something
One to
about
write?
the contracts, but nothing about
well, no questions came up about tort. But we did cover that topic. We spent about half a lecture talking about the topic. I will say, because somebody has mentioned this, somebody has said you've written on this area, and my answer is always I know. And I'm not interested in having my own words repeated back to me. You know, if you're using it for a reason, that's fine, but I don't give you the papers to make myself feel good. I do just fine on my own with that. So if what I've written helps, good. But I would suggest you give yourself enough time for the tort assignment. My impression is that some people may be underestimating the time to think through that topic. Because again, you're looking at the Jones and Tuskegee case from 2012, the Ontario Court of Appeal, and really looking at cases that came after that. What has happened with it? To answer the question, how viable is this privacy tort, which isn't even a privacy tort, right? It's intrusion upon seclusion based upon 1960 article for the California Law Review outlining 4 different privacy torts, which have been adopted in the US in the restatement of tort law, but it's a question as to whether or not in Canada that has been adopted, and if so, how extensively. So I flagged a few things there for you. As I said, if you have to go, please don't let me keep you. but I realize with the last class, there may be some other questions before my parking runs out and York University makes me take this up. So if you have